It's not often I can speak assuredly without someone accusing me of defamation. These days, even when you're reporting facts, if someone doesn't like what you say, they'll label it slander. That's essentially what Meta argued in response to Stephanie Jones' motion to compel user information connected to this Stephanie Jones Lies Facebook page. They insisted she must show that the content was defamatory, yet it wasn't. It falls under First Amendment protected speech. Now, there are individuals with a reputation for consistently spreading falsehoods while driving public narratives. Blake Lively and Ryan Reynolds fall squarely into that category. This very narrative played out in court just yesterday. Remember when I said the era of intimidation was coming to a close? That statement still stands. Some people accused my prior video of being misleading clickbait. But from my perspective, and I think most creators involved in this story would agree, there has been a constant looming threat. Personally, I've received cease and desist letters. Others have been issued subpoenas or publicly defamed. One example is Shasty, who was ridiculed but never even subpoenaed. However, once the judge stated that all subpoenaed documentation must be turned in by July 25th, it signaled a shift. It means no more subpoenas can be issued, which is a relief for independent creators like myself who were at risk of getting pulled into the legal mess. If Perez hasn't yet received a subpoena, he likely won't be involved at all. And if records must be turned over within 2 weeks, people like Candace and Andy could also be out of the crosshairs. This is all extremely positive. It signifies that Blake and her team can no longer use the legal system to target independent voices. When they requested permission to submit their motion, Blake Lively's legal team launched an exaggerated accusation at Brian Freriedman and attached with it a massive 300-page document. This document was prepared by an attorney who represents a former assistant who briefly worked just 9 days for Vin Diesel in 2010. That assistant is now suing Diesel under a newly enacted law championed by Gavin Newsom, which extended the statute of limitations for victims of sexual assault, dating back to 2009. If someone had a legitimate claim from 2009 or earlier, they could now pursue legal action as an employee. However, this didn't change the obligations under the CRD, California Civil Rights Department. The assistant filed a lawsuit alleging things like negligence and workplace discrimination, but all employment-related claims were dismissed due to the time limits. She didn't file with the CRD in time. What remains in the case are just the SA and personal claims. Vin Diesel has denied all allegations. His manager and sister also maintain he wasn't even in California when the incident supposedly occurred. I'm not diving into the merits of that particular lawsuit. It's not directly related to Blake Lively's situation, apart from the fact that Blake's attorneys referenced that 300-page filing. And in that same filing, they conveyed a very misleading, some would say dishonest, portrayal of what transpired in court involving Brian Freriedman. It was a motion to compel Diesel's deposition and request sanctions, filed as an ex parte application, even though they had already filed one previously. So essentially, it was a second attempt tacked on to the first. On the exact same day those 300 pages were submitted, Brian Freriedman's firm issued a response, urging the court to deny the request and detailing all the reasons why. They responded immediately, making their position clear. In fact, within the very first paragraph of their legal response, which, by the way, Blake Lively's attorneys intentionally omitted, the statement was crystal clear. It's now apparent that without court intervention, the plaintiff will ensure this trial proceeds in disgrace. The plaintiff's inappropriate filing is an insult to this court's integrity. It was created solely to demean and falsely accuse the defense counsel. It should be swiftly denied on several legal grounds. That response emphasized the accusations were actionably false, meaning that they weren't just wrong, but could be challenged legally. Blake's team tried to justify the urgency of their ex parte request by arguing they needed immediate court action to avoid harm. Yet they failed to provide any real proof of immediate or irreversible danger. In reality, their motion appeared retaliatory. It was seemingly filed in response to a protective order requested by the defense concerning discovery deadlines and proposed changes to the trial schedule. Everything Blake's attorneys alleged was rejected. Their claims weren't taken seriously. So, if you're going to present one side of a story, you're obligated to present the other. In truth, I don't know exactly what happened behind closed doors. But whatever did occur didn't sway the judge. That's critical. A court notice filed on July 3rd, which Blake and Ryan's lawyers certainly had access to, already outlined an agreement regarding the previous deposition dispute, including any allegations of misconduct or calls for sanctions. And guess what? The court didn't find those claims credible. No money was awarded. Instead, the parties came to an agreement and resolved their issues civilly. Now think about this. If something truly violent or dangerous had happened, would they have just negotiated a settlement? Wouldn't the matter have been escalated, possibly even to law enforcement? According to the official court order, the trial initially scheduled for August 18th has now been pushed to February 2nd, 2026. Likewise, the final status conference that was supposed to take place on August 8th has been rescheduled to January 23rd. All other dates set under the California Code of Civil Procedure and the Los Angeles Superior Court rules tied to the original trial date are now vacated and realigned with the new date, including all discovery deadlines. The court also mandated that the parties must engage in alternative dispute resolution, ADR, such as mediation, by November 7th. A status update regarding that ADR must be submitted by or before that date. Additionally, the plaintiff's motion to compel a deposition set for August 11th, 2025 has been removed from the calendar. Now, why would that be? The defendant's motion for a protective order, scheduled for December 11th, 2025, was also removed. That indicates that both were either resolved or no longer necessary. Instead, the parties came to an agreement regarding the deposition of Vin Diesel. It will occur on September 3rd at the law office of the defendant's counsel. It's been agreed that the deposition won't exceed 7 hours in duration. Originally, the plaintiff had demanded an unlimited length deposition over 2 days, something the court does not allow. Furthermore, a non-party deposition is scheduled for September 12th, and the parties are expected to coordinate on rescheduling other depositions involving non-parties. The plaintiff also agreed to permit the production of documents requested by the defendants from the Walt Disney Company through subpoena and will turn over all copies to the defense. By removing those hearings from the court calendar, it essentially confirms that the motions were denied. The judge clearly wasn't moved by what was presented in those 300 pages. The court's official minute order from the July 1st hearing clearly outlines the outcome. The judge and both legal teams held a conference to address the issues scheduled for that day, particularly around discovery matters. After hearing arguments, the court issued a ruling. The ex parte application to compel the deposition was denied. That means the entire 300-page filing submitted by Blake Lively's attorneys was thrown out. No sanctions, no granted motion to compel. In the end, the content of that document was entirely irrelevant to the case's outcome. But here's the catch. That's not what Blake's lawyers told the court. Instead, they implied that the situation was still unresolved, as if the deposition matter was pending. In reality, during the hearing, all sides agreed to a date for Vin Diesel's deposition, and the judge considered the matter settled. And what's also telling, the order includes no disciplinary remarks against Brian Freriedman or his team. Nothing about misconduct. Nothing about unethical or unprofessional behavior. Zero reprimands. In fact, Brian ended up getting the exact thing he asked for. Vin Diesel being deposed at his own legal office, which was requested for security reasons, ironically similar to what Blake Lively is now asking for in her own legal proceedings. If both parties can agree on such accommodations, they can bring a motion before the judge to intervene. The court may allow it if the reasoning is sound. This kind of manipulation, especially within this specific case, often emerges when you're dealing with what many consider narcissistic litigants. One party might be falsely portrayed, slandered, and defamed, yet isn't the narcissist. Personally, I don't view Justin as a narcissist. In fact, he seems the opposite. From my perspective, Justin doesn't come across as self-serving or ego-driven. He seems more like someone genuinely interested in producing uplifting, feel-good content that carries meaningful messages. He's not chasing huge, explosive Hollywood blockbusters. That said, He was once set to direct a film adaptation of Pac-Man, which has since been shelved. Perhaps that's part of the reason Ryan Reynolds targeted him. Or maybe it's something more personal. Remember, Justin collaborated with Ryan's ex-wife on a film. And now, Scarlett Johansson has risen to become one of the most powerful figures in Hollywood, earning more per film than many of her male peers. She surpassed others in terms of industry clout and earnings. It's not a stretch to think that might bother Ryan. In fact, Scarlett herself commented in an interview, suggesting she found the timing of Ryan Reynolds going after Belden quite suspicious. So, make of that what you will. Now, back to the attorneys in this case. What I find especially compelling is that Blake Lively and Ryan Reynolds have enlisted legal representation from aggressive law firms. For example, Goddle has a history of advocating for underdogs fighting against powerful entities. This is the same attorney who represented the 2 election workers that Rudy Giuliani wrongfully accused of tampering with votes. They won a significant judgment against Giuliani, so large, in fact, that he had to declare bankruptcy. That was a classic case of a small team defeating someone powerful. But now, it's the reverse. These same lawyers who once defended victims are now representing celebrities like Blake and Ryan, seemingly using their legal influence to target people who have less institutional power. It feels completely contradictory to their previous values. That reversal in strategy had me wondering whether that's why Mariel, one of the early lead attorneys on the case, has stepped back from active participation. She was a prominent figure during the initial filings, but her presence has diminished over time. These days, the bulk of the case seems to be handled by Kristen Bender, who is affiliated with Wilkie, a firm known for handling high-profile crisis litigation. Kristen Bender is not a typical sexual harassment attorney. Her specialty is managing public scandals and media blowback. That's an important distinction. Both Wilkie and Mannett are legal powerhouses with substantial financial backing, massive legal teams, and deep industry reach. These are not firms that back down easily. They're capable of completely overwhelming smaller opposition teams simply through the weight of their resources. That's why you have to consider what Justin is really up against. It's not just Blake Lively, or even Ryan Reynolds. It's these vast legal machines supporting them. And despite that, Justin continues to present himself publicly in a more favorable light than Blake. As for Brian Freriedman, his reputation precedes him. He's often seen as an aggressive litigator, someone who doesn't shy away from using the media to defend his clients. Still, he's not working alone. He's backed by a formidable internal team including Ellen Goff and Jason Sunshine. On top of that, he's coordinating with Mitchell Schuster and Kevin Fritz, both from a high-powered New York firm. If you're familiar with Mitchell Schuster, you know he's not new to high-stakes litigation. He has an extensive record representing elite athletes in major leagues, NFL, MLB, you name it. His office is fully capable of handling the kind of tight security that Blake might require if deposed. So, if Blake Lively's legal team truly wanted to accommodate her safety concerns, they have options. They could choose to hold the deposition at a secure location like Mitchell Schuster's firm, just as Brian Freriedman arranged for Vin Diesel's deposition. But instead of cooperating, they chose to pursue a strategy that many view as simply a smear campaign, specifically, an effort to make Brian appear dangerous. What they did in court recently, submitting that misleading 300-page document, seemed aimed at dragging Brian's name through the mud. They blatantly ignored the fact that the judge had already reviewed the issue and had dismissed the sanctions request. There was no finding of misconduct. The allegation against Brian was never taken seriously by the court. It's worth stating again, an allegation is not proof. And in this case, the judge denied the ex parte motion to compel, signaling clearly that the accusations held no weight in the eyes of the court. Ultimately, the issue was resolved. Still, Blake's team continues to act like it's unresolved, as if this proves wrongdoing on Brian's part. To me, this reeks of desperation. That's how I see it. These moves by Blake Lively's attorneys appear to be more about character assassination than legal strategy. And frankly, that kind of behavior from attorneys is deeply disturbing. These are legal professionals who are essentially being paid to discredit Justin Belden and his legal representatives. They even went so far as to present skewed, misleading information to the court to make Brian Freriedman look violent or threatening, claims that were not deemed credible by the judge. Again, I'm not claiming to know every detail of what happened behind closed doors. But I do know this: the judge denied the motion. That tells us it wasn't serious enough to merit any sort of official sanction or disciplinary action. That's just the truth. If the claims had any weight, the court would have acted accordingly. But they didn't. A lot of you have asked me, why do they keep filing so many motions? Is it because they get paid per filing? No. It's not about the number of filings, it's about billable hours. These attorneys are being paid by the hour. So naturally, the more time they spend drafting documents, filing motions, and preparing exhibits, the more money they earn. And when their clients don't care about the expense, or worse, insist on filing even when the case has no merit, the lawyers comply. That's how the system works. Some people try to argue that Ryan Reynolds and Blake Lively have no control over what gets filed. That's just not true. Attorneys can't file anything on a client's behalf without permission. If a motion or complaint is being submitted, the clients are absolutely involved. Most of the time, they've even read it before it goes to the court. After all, it's their name and their interests on the line. So yes, these lawyers are acting on behalf of Blake and Ryan. If the strategy is aggressive, manipulative, or even borderline unethical, it's because they've been authorized to take that approach. As for Kristen Bender, the crisis PR attorney, she's apparently excellent at what she does. But again, her role isn't about sexual misconduct cases. It's about controlling fallout and media perception. And it seems clear that this latest tactic was just that, an attempt to smear Brian Freriedman publicly. But it failed. The judge ignored it. And now, it's official. Blake Lively's attorneys have been caught misrepresenting facts to the court.
Don't miss the next headline. Like, subscribe, and turn on that notification bell.